That's right, Pythagoras. Which city is home to the United Nations headquarters? That's New York City. And here's another one. Which country invented the Olympic Games over 2,700 years ago? If you said Greece, that's correct. The answer is Greece. If you got them right, you're sharp enough to follow the battle of the year. From September 22 to 26, Jamaica's best journalists face off in the nationwide quiz competition. Live from 10:30 a.m. to 11:30 a.m. on Nationwide 90 FM. 5 days, 5 rounds. One winner will be crowned Quiz Champion of the Year. The nationwide quiz competition. Knowledge has no borders and class is always in session.
It's Monday, get over your blues. Or Tuesday, Wednesday, Thursday, Friday. The E-Zone is here for you. With this thing, Honey Bee.
And Karim Boyatings
from 3 to 5 p.m. on Nationwide 90 FM.
We've got your entertainment news.
Then we want to hear your views. Why you say?
Jump in the mix.
Or the hot seat.
Don't miss our brain busters.
Or the crazy giveaways.
Let's talk fashion.
Send us your outfit of the day. Ooh, cutesy. Very demure.
Are you looking for love?
Come on one of our blind dates. Send your request to ezoneblindates@gmail.com. That's ezoneblindates@gmail.com.
And stay tuned for your confessions.
These are my confessions.
Share them with us at ezoneconfessions@yahoo.com. I mean, is this planet Earth?
Is it?
I don't know. Let me check. Either way, it's got a buzz.
And a bugger thing.
Ow! Ow!
Nationwide 90 FM, continuing the tradition of fair, fearless, and factual reporting. You're listening to Nationwide 90 FM. The time is
1 p.m.
The people's champion. Our mission is love. Our vision is love. Jamaicans for justice. The people's champion. Justice, justice for all. Justice under the law. Justice, Jamaica demand. Right to life, right to liberty. Justice, justice for all. Justice under the law. Justice, the people demand. Right to life and security.
Afternoon, welcome to Let's Start Justice. My name is Jade Williams. I'm the Policy Research and Advocacy Manager at Jamaicans for Justice. We are not joined by my usual co-host, Michael Jackson. If you have been listening in on PBCJ since morning, you would know that Jamaicans for Justice has been at the Access to Information Right to Know conference. So Mikkel is there representing the organization, and she will be speaking on behalf of the organization, I think, right now. But don't go there now. You can watch it later. But you stay with us for right now as we delve into an important topic today, discussing the issue of bench trials and whether or not there is a need for reform. So we are going to be joined by attorney at law Tamika Harris. She's also the president of the Advocates Association of Jamaica. But before we get to that, quickly, we have our right of the day and we have our trivia question for today. So our right of the day today comes from one of our oldest rights instruments, actually. It's called Magna Carta, and Magna Carta means the Great Charter, but essentially it was one of the first charters of rights that we had, where we still even had monarchies worldwide at that time when it was created. But this was attributed to as one of the first instruments in which we would have seen our right to trial by jury. In the original Magna Carta, it said, "No free man shall be seized, imprisoned, stripped of his rights or possessions, outlawed or exiled or deprived of his standing in any way, nor will we proceed with force against him or send others to do so, except by the lawful judgment of his equals or by the law of the land." And one of the very common interpretation of this provision, which was at Chapter 39 of the Magna Carta is that this is a guarantee to a trial by jury. So, except by the lawful judgment of his equals, that's where we get that term, the jury of your peers, right? We also have a trivia question for today, and our trivia question for today asks, which section of the Constitution speaks to the powers of the Director of Public Prosecutions? So which section of the Constitution governs the powers of the Director of Public Prosecutions, the DPP? So you can respond by sending a WhatsApp to 2397583. You can put your answer in the Nationwide YouTube chat, or you can respond on JFJ's Instagram at JA4Justice. So, as I said, our topic for today is bench trials and whether or not there is need for reform. Now, discussions regarding jury trials have been prominent over the past few years. High-profile matters such as the trial in the death of Mario Dean, which we've spoken about extensively on this show, highlighted some of the challenges that can arise from low juror turnout and low enforcement of penalties under the Jury Act. Now, in Jamaica, an accused person does not have to be tried by a jury. They can also be tried by a judge alone, or what we call a bench trial. However, this is not automatic, and there needs to be an agreement between the accused, essentially an agreement between the accused and the Director of Public Prosecutions for that to happen. Now, recently we saw a statement coming out of the Advocates Association of Jamaica that argued that this prosecutorial consent that is required is punishing the accused persons without conviction, as many persons spend years in custody while jury trials remain stalled. Now, beyond this, we have questions. Is this a deliberate attempt? Is this an attempt to, quote-unquote, shop for a better tribunal in these matters? So we're joined right now, I think, by attorney at law Tamika Harris, president of the Advocates Association of Jamaica. Tamika, thank you for joining us.
Thank you for having me.
All right, great.
Good afternoon to your listeners.
All right. So I think our first question is, what exactly is the provision? Where do we find it? And what exactly does it say?
What provision in relation to the Jury Act?
No, in relation to bench trials versus jury trial. How that is decided.
All right. So the legislation, you want me to tell you the name of the legislation? I'm not sure exactly what you want to know. The law is, as it stands, is that an accused person has, well, for serious offense like murder and rape, the accused person has the right to do trial by a judge and judge alone and judge and jury. The legislation provides, however, that if a person, which is an accused person, wishes to do a judge alone trial, then that can be accommodated with the consent of the Director of Public Prosecution. So it means that the Director of Public Prosecution would have some form of what we call a veto power in relation to whether a person can be tried by a judge alone.
I think my first question coming out of that would be, does the prosecution have to give any reasons for not agreeing to be tried by a judge alone?
No, the prosecution doesn't need to give any reason at all.
Does the accused have to give any reason to make the application?
No.
Okay. So
the accused normally speaks to his counsel, and the reason they normally give counsel, which is it's a confidential conversation, but the most popular reason coming from the accused persons is the quickness in which a matter can be tried. So a matter that is tried by judge alone is normally heard within a shorter time period, because I'm not going to say a quick time, because it's still a considerable long period of time to wait, but it is shorter than waiting on a trial to be conducted by judge and jury.
Mm-hmm.
So the jury matters, for example, will be set for late 2026, and judge alone matter, you could get one for 2025.
Mm-hmm. So is it that you have seen, I mean, are there any examples that you can give of matters where the DPP's disagreement with going to judge alone would have led to a long delay in the matter?
Yes, I can. So personally, I have represented an accused person who indicated to me that he wants to do his trial by judge alone because he is aware of the trial dates that are being set in the court. Mm-hmm. He's aware that if he's asked for a judge alone trial, he would more likely get a trial date for 2025. And this was earlier in the year. Mm-hmm. The director indicated that she prefers the matter, or she is refusing to consent, and that she wants the matter to be dealt with by judge and jury. She said that she thought that this matter is better be heard by judge and jury. She didn't give a reason why this matter is better. She didn't need it to. The legislation does not provide that she has to give any form of reason. And because of her decision alone, which is to go to judge and jury, the trial date that is set in the matter is late 2026. That is my personal experience. I've also been in we call it the case management court. I've been in the case management court where I hear not the director herself, but Crown Counsel, that is lawyers who is acting on her instructions, indicate that it is a policy of the director's office that certain matters will be dealt by judge and jury. We were not told what are the certain matters, nor were we informed what would cause that decision to be made, and on what basis does the director exercise this discretion. We are not told.
I see. Is it that the okay. I was going to ask, if there is even the possibility of a written policy being in place, but the fact that you weren't even told, I'm going to assume that you wouldn't know that either. So I have to say, JFJ is in support of seeing some reform in this area. We support the idea that, better yet, I should ask you, what were your recommendations in terms of remedying this issue?
Well, my recommendation is that the decision must only be made by the accused person, and the only inquiry that should be made is not from the director of prosecution, but from the accused person himself, whether he is doing this by consent, whether he's aware of the law, whether he was forced to make this decision, and whether anybody unduly influenced him to make that decision. So in other words, it totally should be a reflection of his own will. I do not see any need for the input from the director's office.
So how do you respond to the critique that, the purpose of the director then is to essentially represent the issues that a victim has, and I guess to some extent maybe taking some instructions from the victims, and the DPP's response to this critique was that they're trying to balance the rights of the victim and the accused. How do you respond to that critique?
Well, it is a little concerning because a victim shouldn't really be concerned in relation to the tribunal that hears the matter. The victim should only be concerned whether I would get a voice on whether my evidence would be viewed and analyzed properly, and that can be done by our judges. So unless the director office is saying that they do not have confidence in our judiciary, I do not see how a judge alone would undermine the victims' rights. Because in a society where we are, of course, we are going to be cognizant of the rights of the victims. But I do not see in any way how a judge alone can undermine the rights of the victim, unless we are sending a signal that we do not believe that our judiciary is sufficiently unbiased or sufficiently capable of deciding on the facts of a case. And I'm sure that could never be the view of the director's office. So it brings us back to what is the real reason for the director to be having any form of input in relation to this.
I like I said, JFJ does agree with your perspective where this is concerned, that there certainly needs to be a look at how these matters are handled when it comes to the judge alone versus the jury trial, particularly to the rights of the accused. I know that the provision has had some negative effects. And I also know that there has been some negative perception overall. I know the Chief Justice has been pushing for, bench trials for every matter. And some other persons as well have been pushing for that. JFJ is more on the side of, we want to see jury trials that with an improved jury system, as well as bench trials with the accused having that fulsome option, similar to how Advocates Association articulated it. But I wanted to ask, and we're up on our break, so I'll ask you to just stay with us until we come back to answer this question. But does the Advocates Association have any position on whether or not we should continue to maintain jury trials in light of some of the challenges that we have been seeing in Jamaica?
New semester, your time to win! Pick up True products and you're in. True Ship, True Milk, and True Jokes, True Almond, and True Moto. Refresh your semester in True Style.
Purchase any 6 True products between August 28 and October 13 for a chance to be one of 3 grand prize winners of $200,000 or 7 weekly winners of $15,000 in supermarket or book vouchers. Visit Tradewinds Citrus on IG for details.
New semester, your time to win. Refresh your semester in True Style.
Conditions apply.
Authorized by the Betting, Gaming and Lotteries Commission.
Welcome back to Let's Talk Justice. We are discussing the matter of bench trials and the need for reform. I'm joined by attorney at law and president of the Advocates Association of Jamaica, Tamika Harris. Ms. Harris, before the break, I was asking you if the Advocates Association had any position on the maintenance of jury trials, considering the issues that we've been seeing.
We have no issue with jury trials. The issue, of course, is whether the jurors are given their stipend. Now we understand the difficulties. Mm-hmm. The issue is whether enough summons are served on the jurors. The issues in relation to the jury trial, the jury system must be improved, but at all times we are maintaining that judge and jury should be maintained. Mm-hmm. The accused persons should have the right to determine if the matter is to be judged alone, and it is the accused person alone who is to determine that right. We understand that one might say that the victim should have some input, but at the same time, we must realize that the accused person's liberty is the one that is at stake, and the victim's liberty is not at stake at all.
Yes.
Though they are important, they do not have the same risk that the accused person has in relation to their liberty.
Yeah,
why they should be dictating the mode of trial. I really cannot see how and why they should be dictating the mode of trial at all.
Yeah, I can completely, I understand. And one of the issues that we've seen a lot at JFJ is how delays can affect, the quality of a trial, the availability of witnesses, the quality of evidence. I don't know if you can speak a little bit to the challenges that brings.
Well, the delay affects not just the prosecution, so it also affects the defense.
Mm-hmm.
So defense witnesses perhaps pass away, defense witnesses no longer have any interest, move to a different community, we can't find our witnesses similarly to the prosecution. It doesn't assist any party, none of the parties, whether accused nor prosecution witnesses. So the delay is a problem that has to be dealt with real effort and not just with lip service.
All right, thank you so much for that, Miss Harris. I don't know if there's any other point on this issue that you'd want to share with our listeners to just help them to get a better understanding.
I didn't want to say that, but it's in my it's playing on my mind, and I think I should say it. The director's position may not, on the face of it, seem alarming to many, because they believe that, defense counsel is always just defending accused persons. But we are looking on the overall system. We are looking at the overall people that trust the system and believe in justice. And we have to balance the powers. The accused person is coming with just an attorney. Mm-hmm. The victim has the entire backing of the police, the entire backing of the Director of Public Prosecution Office, the whole state resources, the medical officers. So when we look at the balance of power really rests strongly and heavily on the prosecution side. The accused person is really sometimes just before the court like a lamb to be slaughtered. Mm-hmm. And not all persons who are charged are guilty. There are many innocent persons before the court. There are persons who give false evidence, give false statements, who are forced by the dons in the community to give a false statement against John Brown because they don't like John Brown. So when we look at the rights of an accused person, we must be cognizant of the fact that, yes, Jamaica is high crime, but at the same time, we must remember that it's a balancing exercise, and an accused person is innocent until proven guilty.
Thank you so much for that, Ms. Harris. I really appreciate that statement. I think it's something that we have to constantly drill into persons, because once someone becomes even slightly in conflict with the law, we start to throw the book at them. And I think we need to always be reminded that the reason they're in conflict with the law is to determine whether or not they're guilty, and not just by virtue of being conflict that they are guilty. So thank you so much for that. I appreciate you joining us. I don't know if you have a last word on this issue.
No, I don't have any last word, but thank you very much for having me. We have several other issues that we would like to tackle. So perhaps I can partner with Jamaicans for Justice, for example, and have a look at the Firearms Act, because that also is another whole ball game of injustice.
I know you have to go, but I just want to say that we did make a submission on the Firearms Act. We were late with the submission, so I'll admit that. But we did make a submission on it because we saw a lot of glaring challenges, particularly with how minors are treated under the legislation, the mandatory minimum sentences. So
yes.
Yeah, we were. We'll be happy to engage you. Say that again?
I said, so we need to be joining forces.
Yeah, absolutely. And we'll definitely engage you on a discussion about that particular legislation, because it's something that really concerns us going having seen the review before it was amended. So thanks again, Ms. Harris, and we'll speak, right?
Thank you. Have a great day. And thanks to you and your listeners.
All right, that was Tamika Harris, the president of the Advocates Association of Jamaica and attorney at law. You know, a lot of things that came out of that discussion are issues that JFJ has been harping on for quite some time. One of the major challenges that we have been speaking to is the state of our jury system. We've been promised a lot of different levels of reform over the years, and some of them happened. You know, we did see some amendments to the legislation, I think in 2016, where we saw an increase in a few fees. However, we continue to have challenges. I know that some persons from lower socioeconomic areas struggle with the cost of coming to court, of staying there all day, not being able to do their work. Some of them do days work, so you would need to be at work in order to make money. And the stipend that's being provided is vastly insufficient for that kind of commitment. Another issue that we see is where employers might be the challenge. You know, you have your jury duty to go and do, and your employers are not willing to release you. Now, the Jury Act does speak to the fact that you are to be released, similar to how your ECJ Act would speak to your right to leave work and go and vote on election day. But enforcement, the provisions being there versus enforcement, you know, is always two different ball games. So it is concerning when persons are summoned for jury duty and their employers are telling them, oh, they can't go. And then, you know, we have the other side of it where some of us are simply not taking up our civic duty. So you are summoned for jury duty, and then you go to your doctor friend and you ask for a nice little note so that you don't have to show up to court. There's nothing really wrong with you, but you just don't want to go. Or it is that you get this summons and you don't bother to go, and you are fined and you just pay the fine because it's no big deal to you. Or another thing that we're seeing too is the service of the summons, which Miss Harris mentioned, and it was something that came up quite a bit in the Mario Dean matter, where we saw the judge scolding a bit the JCF in Montego Bay in St. James regarding the summonses that were served. So we saw, I think it was 15 summons. I can't remember. This is why I need Mikel, because Mikel has the memory to tell me the exact amount. But there was a court date where the judge was essentially livid to find out that the summons that were served was maybe 15, 20 summonses for a matter that had 3 accused persons. And I think what a lot of people don't get too about the jury trials is that each accused person has some options. You know, each accused person can dismiss a juror for no reason, 3 jurors for no reason. And then there are further dismissals that you can ask for with reason, you know, whether conflict of interest or other issues. So you need, depending on the matter, 7 to 10 member panel of jurors to hear the matter. And in that case, you and 3 accused people, you would need to have so many, at minimum 30 people at least, to be there to go through to ensure that the jury is empaneled on the same day. And even in that matter, it did not happen. We had the turnout, but the empaneling did not happen on the same day, just because of the process and how long that took, vetoing the different jurors, asking them questions. So it is really something that when we look at our legislative reform, as we talk about, you know, looking at the trial system, jury trials, and how we support jurors and how we enforce the Jury Act, is something that we have to be looking more deeply at. I know Minister Chuck had promised us reform in this area in throne speech last year and the year before and the year before that. So I'm hoping that we will continue, we will see some action in the area as we see that expansion of the Ministry of Justice now into the Ministry of Justice and Constitutional Affairs. So hopefully we are able to see some improvement in the jury system. Now, we have been discussing the matter of bench trials, and I just wanted to say for the listeners that you find this provision that we were discussing in the Criminal Justice Administration Act at section 11A, where it says that, you know, the prosecution has to agree with the accused in order for the matter to go to a judge alone trial. Now, what that section also says is that this does not apply to certain offenses that are under section 31 of the Jury Act, and section 31 of the Jury Act speaks to treason, which is a very serious matter, and capital murder, which has to do with, you know, the killing of important persons like police officers or presidents, or gruesome killings, right? So those offenses, you know, you would have to be tried by a jury. That's what our legislation specifies. But in other serious offenses, in fact, it says in a indictable offense. So that's why we say serious offenses, because it goes to a higher level of the court. And in those situations, the person can ask for that bench trial. So we are up on another break. And when we come back, we'll discuss some more issues related to law reform.
At the Jamaica Customs Agency, we care for our employees, customers, stakeholders, citizens, and our country. Customs cares. The temperature by the Jamaica Customs Agency is
31 degrees in Kingston, 31 degrees in Montego Bay.
Need reliable security for your business? Dual Protective Security is the perfect choice, providing round-the-clock security solutions and customer support. Our security experts will work with you to create customized solutions that fit your needs and budget. Contact us today and enjoy the peace of mind you deserve with their unbeatable security services. Dual Protective Security. Call 876-676-6987 or 876-415-4564.
School is back in session, so let's see if you are quiz competition ready. In a right-angled triangle, the square of the hypotenuse equals the sum of the squares of the other two sides. Who gave us that theorem? That's right, Pythagoras. Which city is home to the United Nations headquarters? That's New York City. And here's another one. Which country invented the Olympic Games over 2,700 years ago? If you said Greece, that's correct. The answer is Greece. If you got them right, you're sharp enough to follow the battle of the year. From September 22 to 26, Jamaica's best journalists face off in the nationwide quiz competition. Live from 10:30 a.m. to 11:30 a.m. on Nationwide 90 FM. 5 days, 5 rounds. One winner will be crowned Quiz Champion of the Year. The nationwide quiz competition. Knowledge has no borders and class is always in session.
Welcome back to Let's Start Justice. We had been discussing the issue of bench trials, jury trials, and all that. And general law reform, I would say. Before the break, I was just articulating some of the challenges that we have seen with the implementation of our Jury Act provisions. I saw quite a few social media posts coming after Justice Sykes made another of his statements. I know that Justice Sykes is very much an advocate to see bench trials as the only trial format that we have here There are other jurisdictions that do that. I think Australia does it as well, where there are no jury trials, and I think there are very few places that have a right to jury trial, like the United States has a right to jury trial. What we have here in Jamaica is not a right to jury trials, but a right to a fair trial in a reasonable time, right? So it doesn't go so far as to be a jury trial right. However, all of our legislative instruments indicate that is the major trial format that we use here. But JFJ has always been an advocate for the maintenance of our jury trials and then the improvement of our jury system. Other improvements that we've been looking for and advocating towards are those mandatory minimum sentences, and we heard Ms. Harris bring up those sentences during our discussion in relation to the Firearms Act. Now, we've had mandatory minimum sentences for quite some time, and that basically means that it is a sentence that the legislation determines, right? So say, for example, you are caught stealing and there is a mandatory minimum sentence for stealing that is 5 years. That essentially means you cannot get less than the 5-year sentence, regardless of the circumstances that occur. Now, we saw mandatory minimum sentences introduced in they were already there, but changed in our Firearm Act in 2022. The original iteration of that legislation was quite alarming because that mandatory sentence was a life sentence. However, once the legislation was amended prior to passing, that was reduced to a 15-year mandatory minimum sentence. Even at that time, with that reduction, we had flagged the issue of children under the legislation and how children are treated. I think one of the issues that I've seen with legislation generally in Jamaica is that we kind of assume that the child will just fall into a category rather than specifying how they are to be treated, or we say they are to be treated in the same way that they're treated under the Child Care and Protection Act, but then the Child Care and Protection Act doesn't speak to the specific offense, or it doesn't have a particular provision that it is pointing to for you to understand exactly how a child would be treated in these situations. And that is a problem when it comes to these mandatory minimum sentences. There is some common law precedent, for the judge to look at the circumstances of a minor and try to make adjustments. But generally speaking, a mandatory sentence is a mandatory sentence. So you will be getting that mandatory minimum sentence as a 15-year-old forced into bringing a firearm or any other circumstances of that nature, right? So it is something that we have been advocating for review of. We did hear recently that is in the plans for our new cabinet to be looking at a review of this firearms legislation. So hopefully we are going to see that in Parliament soon. And hopefully we will also be taking submissions from the public, because I think in the previous review of that legislation, it was quite daunting. Even as an attorney myself, reading through the proposals and the 2022 provisions of the Firearms Act, it was quite daunting. So it is something that I'm hoping they'll open up to the public and give everyone the opportunity to go through and really understand that legislation before they are able to make submissions. Now, as we stay on the topic of law reform, I mentioned to the listeners earlier that the JFJ team is currently with the Access to Information Unit. They're hosting their Right to Know conference today at the AC Hotel. and we are speaking on the matter of access to information. And we've been beating down on you all on the matter of access to information for the past few weeks, but I think it is something that we are not taking seriously enough. And so we have taken up a real interest in ensuring that persons are using this legislation, because I think part of the reason that we're not seeing any alacrity in the reforms that are necessary for that legislation is that people think it's not being used, right? But we saw part of the discussions today at that ATI conference from JET and from other NGOs about the long-awaited reform that we wanted to see for the ATI Act. The Act was reviewed in 2011. There was a Joint Select Committee report produced, and since then there has been little to no action on the legislation. We did hear from varying ministers of information that the report was with Cabinet, that the Cabinet was considering the provisions in the report, and that they would be determining if it can be implemented as is, if it should go back to Parliament. We have heard that up to as recently as earlier this year. We'd love to know where we are, where that legislation is concerned in terms of review, because we are seeing challenges. We have a new Data Protection Act that is not interacting very friendly with the ATI Act based on how persons have interpreted the two pieces of legislation. Now, we are of the view that the Data Protection Act should not be influencing any of the provisions in the Access to Information Act based on how we have been made to understand both legislation. However, not everyone who is charged with implementing these pieces of legislation are of that same view. And that clarity is absolutely necessary, because persons are having their rights restricted arbitrarily because we are not able to fully understand how these provisions are to interact with each other. You know, I think, one, if it is that you are interested in making an access to information request, JFJ has started up a portal for you to do that at righttonowja.com. It includes all of the public authorities, ministries, departments, any agency other than the private companies, but any agency that is to have an access to information officer falls under the Access to Information Act. You can find information on the site as well about using the ATI Act. And if you needed advice as to how to make that ATI request, you could always call us at the JFJ office at 755-4524, where we'll be able to walk you through using the form or doing a request outside of the website. But we have been pushing our access to information agenda and as part of that, we do have coming up on the 12th of November our Access to Information Public Forum, where we will be opening dialogue with persons about where that legislation needs to go, some of the issues that we've been able to glean from the research that we have been doing on the legislation and the implementation of the legislation. And we continue to see issues with keeping the timelines, issues with the kind of information that is being exempted, misunderstandings of the provisions. So we definitely need to do a bit more public education around the legislation, and we also need to see the public more engaged with the issue of access to information. I heard Mikkel earlier on another radio program speaking to the need for civic involvement, and I think everybody has been beaten down on this, especially coming out of an election season where we had low voter turnout, but we want to see persons in the country interested in the things that are here. We have some of the most advanced frameworks in the Caribbean when it comes to rights. We have an excellent Charter of Rights. We have this Access to Information Act that fulfills your right to seek, disseminate, receive information. You know, we have our Integrity Commission that looks at corruption issues, our INDICOM that looks at police abuse issues. We are doing so well in terms of systems set up for transparency, but if it is that we're not using those systems and those mechanisms, then of course we're not going to reap the benefits from them. So it's important that we take up that civic responsibility to use those items, to use those avenues that we have to seek redress, to seek information, and to ensure that they work, right? Because part of the reason that JFJ knows how this access to information legislation has been implemented is because we use it, and agencies like Jamaica Environment Trust and others use it as well, and would be able to glean from that use what needs to be improved, where we need resources, the increased number of ATI officers that we might need, the fact that digitization is still so slow in some agencies. I know, for example, at the Department of Correctional Services, digitization is happening, but not at a rate where you can make an ATI request and get your request in a short period of time. We struggle to get the request within the statutory time limit due to those limitations. That's not exactly the fault of the ATI officer, but the fault of the systems that are there to support that officer in fulfilling our rights to seek, receive, and disseminate information. So it is definitely something that we will continue to push at JFJ, and we look forward to you all joining us at the public forum. We will have an outside broadcast. I can't remember who is doing it, so I won't mention that. But you will get more information on our social media pages regarding that public forum closer to November 12th. But mark the date on your calendars, because we will be there giving you what you need to know about the act, and also what we would like to see in terms of reform. So we're up on another break, and after this we will wrap up with you all.
Do it for your best life. Right. Go check your HIV status. Right. So keep your life trending, no pretending. Me I tell yourself it, do it for you, do it for you. Every time you are link with a condom, coulda husband, coulda wife, coulda be a random. Condom connect and protect your profile. Be your own fan. Do it for your best life. Right. Do it for your best life. Right. Don't put yourself at risk. Condom connect every time. Do it for your best life. Right.
Are you ready to turn your sales and marketing skills into high earnings? Nationwide 90 FM is searching for business development executives to build lasting client relationships. If you have experience across all stages of the sales cycle and possess strong communication, negotiation, and time management skills with a proven sales track record, this opportunity is perfect for you. Join our team and work with the top corporate brands, media agencies, and of course, our on-air personalities. Enjoy networking opportunities, professional growth, and competitive commissions. Ready to take the next step? Send your resume to hr@nationwidenewsnetwork.com today.
Welcome back to Let's Talk Justice. We've been discussing a lot of different areas of reform. We started with bench trials, and then we moved on to mandatory minimums and access to information. We're just covering everything today, right? But I'm seeing a message here in the Nationwide chat that says some of these mandated sentences should definitely be higher. Some spit in the face of victims and their families. One of the things that JFJ has had on its reform agenda is sentencing. We have been seeing a lot of disgruntlement related to the sentences that are handed out to persons. In fact, it's something that our next e-brief will be on. So if you follow JFJ's Instagram page or any of our social media pages, you would know that we put out a newsletter, an e-brief that covers justice issues. It's called Justice Matters, and covers issues that we need for legislative and justice reform. And the next issue is specifically on the matter of sentencing and the need for sentencing reform. Now, one of the things that we are not in agreement with is that we need high mandatory minimum sentences. We find that high mandatory minimum sentences do a lot more harm than good, especially in a situation like ours where we have an extreme issue with overcrowding in our prisons, in our jails, and mandatory minimum sentences exacerbates that issue. Even jurisdictions that implemented numerous high mandatory sentences, the US most notoriously is known for this, has had to roll them back, or they've created a kind of industrial complex to house all of these inmates that they would have had coming out of changing these sentences. So, you know, what we want to see from JFJ's perspective is a look at our sentencing guidelines, our sentencing structure, and maybe considering whether or not we need something like a sentencing council that we have seen in places like the UK or in the Eastern Caribbean, where you would be looking at how sentences are implemented in each case, actually doing analysis, looking at the factors that judges are considering to see whether or not reform needs to be done in the area, right? And the purpose of that sentencing council now would be to continuously do that work. So, you know, we really appreciate the sentencing guidelines that we have that came from Justice Zelia McCullough, who, you know, really spearheaded that implementation of guidelines. But, you know, one of the things that we see where it differs, and I would say in a lesser way, that it differs from, you know, guidelines in like the Eastern Caribbean or guidelines in the UK, Australia, which are all Commonwealth jurisdictions similar to Jamaica, is that they have specifics, right? So if you look at a offense like rape, in Jamaica, we have a mandatory minimum sentence for rape, that is 15 years. And then we have guidelines that speak to the starting point of the sentence that the court will consider. Now, when the court looks at the starting point, they're like, okay, we're going to start here, and then we're going to either add or reduce the sentence based on aggravating or mitigating factors. Now, in Jamaica's sentencing guidelines, the way that it works is we have a list of aggravating and mitigating factors, and then we have a list of offenses. But the aggravating and mitigating factors, they're not attached to the list of offenses. So you'll see, okay, the mandatory minimum sentence is rape, the average starting point for these sentences, and don't take me on my word for this, I'm just giving you examples, but the average starting point for this sentence, you may say, is 20 years, right? So now you're going to start from this 20 years and you're going to decide, am I going to go above the 20 years because the victim was a child, because the person used a weapon in the matter, because the person has previous convictions, and you can decide to go up, or you can decide to go down because this is their first offense, or because the perpetrator is a minor, or because you know, whatever other mitigating factors. We have several, right? But in the Eastern Caribbean and in the UK, for example, what you would see is you have the offense of rape, you have a starting point of 10 years, 15 years, and then the guidelines gives you the specific aggravating and mitigating factors for that specific offense. So instead of it being a general aggravating and mitigating factor, it is aggravating and mitigating factors that apply specifically to that offense that the court is looking at then. And I think that using that method allows for when sentencing guidelines are being reviewed, allows for there to be actual data that looks at how these aggravating and mitigating factors are applied, so that we would know whether or not there are changes that need to be made in the guidelines. But listeners, we will have our e-brief out, so you will be able to read all of our thoughts on the issue of sentencing. But it is something that we have been looking at extensively. It was even something that made up a part of our submission when we spoke on the issue of mandatory minimum sentences in the Parliament last year, because as much as we are against that continuous increase in mandatory minimum sentences, we understand that the Parliament is trying to solve a problem. It is trying to look at the dissatisfaction that many victims feel when a matter is assessed in court and the sentence comes out and they feel as though it is not sufficient for the crime that was committed, right? But that is where the guidelines come in, and I think we can be a lot more nuanced than implementing just broad brush mandatory minimum sentences, which in the long run will end up costing us as taxpayers to host this bevy of prisoners for this extended period of time, right? But I have one final thing to say before we go. We do have our Run for Rights coming up. Now, some of you joined us last year. It was an amazing experience. I was one of the runners. I was the only JFJ staff member to run. Hopefully that will not be the case this year. I'm looking at my producer behind the screen, and I hope that my colleagues at the office are listening in to know that I expect to be joined on race day this year. But race day this year is November 30th, and we are doing our categories again. So you're running for your human rights and your child rights and your gender-based violence. So we will be having, if you look at our social media pages, you will see that you can register for the run now. The registration link is open, and it is in our link tree on Instagram, on Twitter, and if you just need to get the link, you can always message 2397583 and we will forward the link to you so that you can register. But for those of you who are passionate about your human rights, you are passionate about seeing improvement for victims of domestic and gender-based violence, you are passionate about child rights, or you are passionate about climate justice, because I know some of us are in those areas that are affected by bauxite mining, by deep sea mining, right? So you can come and join us on November 30th. We will be at the Police Officers Club, I believe. Yes, we will be at the Police Officers Club, and we'll start from there, and it's going to be a great day. It's going to be a good little 5K. I'm hoping some of us in the nationwide chat will be there. News commentator, I'm hoping to see you on the 30th. But yes, Run for Rights is upcoming. All right, so we have a winner. Well, we have a winner for a trivia question. And that person is... Did you send me the... Oh, okay. Yes, a news commentator was the winner. And the question that we had asked today was, which section of the legislation, of the Constitution, speaks to the powers of the Director of Public Prosecution, and that is section 94.3 that speaks to the powers of the Director of Public Prosecution, and that person has the power to prosecute all the offenses in Jamaica, right? So you'll even find that in other pieces of legislation that have prosecutorial elements, like for example the Integrity Commission Act or the Indicom Act, that the Director of Public Prosecutions is still the authority that is given the power to initiate, take over, discontinue criminal proceedings, right? And we know here in Jamaica the DPP also has the power to appeal certain aspects of the proceedings. So if it is that the sentence, the the DPP is not satisfied with the sentence, they can appeal it. And we did see where we considered the DPP having the ability to appeal an acquittal as well. So Section 94.3 of our Constitution gives the DPP those powers. So we're at the end of our discussion for today. Thank you so much for joining us. As I said, we'll have our e-brief out on Instagram, so keep looking out for that on sentencing, and we'll be talking a bit more about ATI and about justice reform generally over the next few weeks, so continue to tune in, and we'll see you on the 30th at Run for Right. So thanks again for joining us. My name is Jade Williams, Policy Research and Advocacy Manager at Jamaicans for Justice. We'll see you next week.
Jamaicans for Justice, the people's champion. Justice, justice for all. Justice under the law. Justice, Jamaica demand. Right to life, right to liberty. Out of many we are one in a Jamaica. Make it a better place for the boys and girls. Created equal by the creator. For equal rights and opportunities. No to unlawful detention and police brutalization. Class, gender, race or religion. We not tolerate discrimination.
To join the fight against injustice, contact us at 755-4524 or Jamaicans4Justice.org.
The people's champion.
Tune in to Nationwide 90 FM, the new revolution in media.